The alarm bells are ringing across immigrant communities right now. Your phone is buzzing with WhatsApp forwards. Facebook groups are exploding with panic, and people are flooding forums asking the same terrifying question. Did USCIS just make it impossible to afford premium processing? Are green card timelines about to spiral out of control? Did they just double the fees overnight without warning? If you're sitting there right now feeling that knot in your stomach, wondering if this means your case is going to be delayed for years, or if you made a terrible mistake by not filing sooner, I need you to take a breath, because in the next few minutes I'm going to cut through the noise, verify what actually happened, explain exactly what this means for your immigration case today, and most importantly, tell you the truth about whether you need to panic or not. This is Saqib with Global Immigration Updates, and you're about to get the facts. Let's start with what actually happened, because understanding the truth is the only way to make smart decisions about your immigration future. On January 6, 2026, the United States Citizenship and Immigration Services, known as USCIS, officially announced an adjustment to premium processing service fees. This is not a rumor. This is not speculation. This is official federal government action that has been published in the Federal Register and announced through official USCIS channels. But here's what you need to understand immediately. This is not some sudden overnight change that caught everyone off guard. This is not USCIS arbitrarily deciding to charge more money because they feel like it. This is a legally mandated adjustment that happens according to federal law, specifically tied to something called the Consumer Price Index, which measures inflation across the United States economy. Let me explain exactly what premium processing is, because if you're new to the immigration system or if you haven't needed this service yet, you might not fully understand what we're talking about. Premium processing is an optional expedited service offered by USCIS for certain types of immigration petitions and applications. When you pay for premium processing, USCIS guarantees that they will process your case within 15 calendar days. If they don't meet that 15-day deadline, they are required by law to refund your premium processing fee, although your case will continue to be processed. This service is currently available for specific form types, including Form I-129 for non-immigrant workers, Form I-140 for immigrant workers, Form I-539 for extending or changing non-immigrant status, Form I-765 for employment authorization in certain categories, and Form I-924 for regional centers under the EB-5 program. Now here's the critical detail that's causing confusion. Premium processing fees were previously set at $2,500 for most form types. Under this new adjustment announced in January 2026, the fee is increasing to approximately $2,705 for most eligible forms. The exact amount can vary slightly depending on the specific form type and category, but we're talking about an increase of roughly $200, not a doubling, not a tripling, not some astronomical jump that makes the service completely unaffordable. This is an inflation adjustment of approximately 8%, which actually aligns with cumulative inflation rates in the United States economy over the past several years since the last fee adjustment. Let me be extremely clear about something that's causing massive confusion on social media right now. This fee increase is not arbitrary. Under federal law, specifically the Immigration and Nationality Act and related regulations, USCIS is required to periodically review and adjust its fees to reflect the actual cost of providing services. These adjustments must go through a formal rulemaking process that includes public notice, opportunity for public comment, economic analysis, and final publication in the Federal Register. USCIS cannot simply wake up one morning and decide to charge whatever they want. Every fee adjustment must be justified based on actual operational costs, inflation, salary increases for federal employees, technology upgrades, and other documented expenses related to processing immigration benefits. What does this mean for you right now today? If you are currently in the middle of preparing an immigration petition or application and you are planning to use premium processing, you need to know when this fee increase actually takes effect. According to the official USCIS announcement, the new premium processing fees will take effect on a specific date that will be clearly stated in the Federal Register notice. Typically, USCIS provides at least a 30 to 60-day notice period between the announcement and the effective date, giving applicants and petitioners time to prepare and adjust their budgets accordingly. If you file your petition or application with the premium processing fee before the effective date, you will pay the old fee amount. If you file on or after the effective date, you will need to pay the new fee amount. This is straightforward, this is predictable, and this is how federal fee adjustments have always worked. Now let's talk about what has not changed, because this is just as important as understanding what has changed. The eligibility criteria for premium processing have not changed. If your form type was eligible for premium processing before this announcement, it is still eligible now. If your form type was not eligible before, this fee adjustment does not make it newly available. The 15 calendar day processing guarantee has not changed. USCIS is still required to make a decision on your case within 15 calendar days of receiving your premium processing request or refund your fee if they don't meet that deadline. The standard processing times for cases filed without premium processing have not changed due to this fee adjustment. If you choose not to pay for premium processing, your case will be processed according to normal USCIS processing times, which vary by service center, form type, and current caseload volumes. Let me address the most common fear I'm seeing in comments and messages right now. Does this mean USCIS is trying to force everyone to pay for premium processing by deliberately slowing down regular processing? Absolutely not. And here's why that doesn't make sense from a legal or operational standpoint. USCIS is legally required to process all applications and petitions in a timely manner, regardless of whether premium processing fees are paid. Deliberately delaying cases to extract premium processing fees would violate federal administrative law and could result in lawsuits, congressional oversight, and potential legal liability. In fact, USCIS has faced multiple lawsuits over processing delays in recent years, and federal courts have ordered USCIS to process cases within reasonable timeframes. Premium processing exists as an option for applicants and petitioners who have urgent business needs, time-sensitive travel plans, or other legitimate reasons to need faster processing. It is not and has never been a requirement for getting your case approved. Let's talk about the inflation factor, because understanding this helps you see why this adjustment is actually reasonable and expected. Since the last major USCIS fee adjustment several years ago, the United States has experienced significant inflation. The cost of everything from office rent to employee salaries to technology infrastructure has increased. USCIS is required by law to be a fee-funded agency, meaning it must cover its operational costs primarily through the fees it collects from applicants and petitioners, not through general taxpayer appropriations. When inflation increases the cost of providing services, but fees remain frozen, USCIS faces budget shortfalls that can actually lead to slower processing times, furloughs of immigration officers, and degraded service quality. Adjusting fees to keep pace with inflation is actually necessary to maintain the capacity to process cases efficiently. Here's something that might surprise you. Compared to inflation-adjusted costs in other areas of the economy, this premium processing fee increase is actually relatively modest. If you look at the cost of legal services, medical procedures, higher education, or housing over the same time period, you'll see increases that often exceed 8%. I'm not saying this to minimize the financial burden on immigrant families, because I know that every dollar matters when you're navigating the immigration system, often while supporting family members, paying for legal representation, and managing the uncertainty of your immigration status. What I'm saying is that this increase is not evidence of USCIS gouging applicants or trying to make immigration unaffordable. This is a standard inflation adjustment that any organization, whether government or private sector, would need to make to continue operating sustainably. Now let's get practical, because if you're watching this video, you probably have real decisions to make about your own immigration case. If you are planning to file a petition or application with premium processing in the near future, should you rush to file before the fee increase takes effect? The answer depends entirely on whether your case is actually ready to file. The most expensive mistake you can make in immigration is filing a petition or application before it's properly prepared, complete, and supported by all necessary evidence. If USCIS issues a request for evidence because your petition was rushed and incomplete, you've now added months to your processing time, added legal fees to respond to the RFE, and potentially increased the risk of denial. Saving $200 on the premium processing fee is meaningless if it results in a denied petition that costs you thousands of dollars and months or years of delay to refile. If your case is already fully prepared, all supporting documents are gathered, all forms are completed accurately, and your immigration attorney or accredited representative has reviewed everything and confirmed it's ready to file, then yes, filing before the fee increase effective date will save you approximately $200. But if your case is not ready, if you're still gathering evidence, if you're waiting for documents from your employer or from foreign government agencies, if your attorney has told you that certain aspects of your case need more work, do not rush to file just to avoid a $200 fee increase. The risk is not worth the small savings. Let me talk about an alternative that many people don't consider. You may not need premium processing at all. I know that when you're living in immigration limbo, when your future feels uncertain, when you're counting down the days until you can travel, change jobs, or bring family members to the United States, the idea of waiting months for USCIS to process your case feels unbearable. But here's the reality. The vast majority of immigration petitions and applications are filed under standard processing, not premium processing. Standard processing is not a second-class service. It's the normal process that millions of applicants use successfully every year. Unless you have a genuine urgent business need, such as an immediate job start date that cannot be delayed, an upcoming business trip that requires valid immigration status, or another time-sensitive situation, you may be better served by filing under standard processing and saving the premium processing fee for a future case where you truly need expedited processing. Here's what you need to understand about USCIS processing times in general, because this connects to the broader question of whether this fee increase signals anything about USCIS priorities or capacity. USCIS processing times fluctuate based on a complex set of factors including congressional appropriations, staffing levels, policy changes, litigation, technology upgrades, and external events like the COVID-19 pandemic, which created massive backlogs that USCIS is still working through. Premium processing fees fund additional staff and resources specifically dedicated to meeting the 15-day processing guarantee for premium cases. Standard processing times are funded through a combination of standard filing fees, congressional appropriations, and operational efficiencies. These are separate funding streams with separate staffing allocations. An increase in premium processing fees does not take resources away from standard processing cases. Now I want to address something I'm seeing in a lot of comments and social media posts. People asking whether this fee increase means that USCIS is preparing for major policy changes under the current presidential administration. Let me be very clear about this. Fee adjustments and policy changes are separate processes governed by different legal authorities. Fee adjustments are based on the Administrative Procedure Act, federal rulemaking requirements, and statutory obligations to ensure USCIS remains financially sustainable. Policy changes related to immigration enforcement priorities, eligibility criteria, or evidentiary standards go through entirely different processes, including publication of policy memoranda, updates to the USCIS policy manual, and in some cases formal rulemaking or legislative action by Congress. You cannot infer policy changes from fee adjustments, and you should not assume that a fee increase signals anything about eligibility requirements, approval rates, or enforcement priorities. What you should pay attention to instead are official policy memoranda published by USCIS, updates to the USCIS policy manual, which is the authoritative source for how USCIS adjudicates different benefit types, Federal Register notices that announce changes to regulations or procedures, and guidance issued by the Department of Homeland Security or the State Department. These are the sources that will tell you about actual changes to immigration law and policy, not fee adjustments that are required by inflation accounting. Let me give you some practical guidance about managing immigration costs in general, because I know that the cumulative expense of immigration petitions, filing fees, attorney fees, medical examinations, translation services, and other requirements can be overwhelming, especially for families who are already stretching their budgets to make ends meet in an expensive economy. First, always budget for immigration expenses well in advance. If you know you'll need to file a particular petition or application in the next year or two, start setting aside money now. Immigration fees don't decrease. They only stay the same or increase over time due to inflation adjustments. Second, Work with a qualified immigration attorney or accredited representative who can help you develop a strategic filing plan. Sometimes filing certain applications in a particular sequence or waiting for specific events to occur before filing can save you money and reduce the total number of applications you need to file. Third, be extremely cautious about immigration service providers who promise discount fees or special deals that seem too good to be true. USCIS filing fees are set by federal regulation and are the same for everyone. If someone tells you they can get you a special discount on USCIS fees, they are either confused or they are attempting to defraud you. Now let's talk about what you should actually do in response to this premium processing fee increase. If you have a petition or application that you're planning to file with premium processing, review your timeline and confirm the effective date of the new fees by checking the official USCIS website and the Federal Register. If your case is ready to file and you can submit it before the effective date, you'll pay the current fee. If your case will be filed after the effective date, budget for the new fee amount. If you're working with an immigration attorney, discuss whether premium processing is truly necessary for your situation or whether standard processing would be sufficient for your needs. If you cannot afford premium processing at either the current or the increased fee level, file your case under standard processing and monitor USCIS processing times for your form type and service center to get an estimate of how long you should expect to wait. Here's something critical that I need you to understand. The most important factor in immigration case success is not how much you pay in fees. It's the quality and completeness of your petition or application. USCIS adjudicators are required by law to evaluate your case based on whether you meet the legal eligibility requirements, whether you've submitted all required evidence, and whether your petition or application is approvable under current law and policy. Premium processing gets you a faster decision, but it does not increase your chances of approval. A well-prepared case filed under standard processing will be approved. A poorly prepared case filed with premium processing will be denied in 15 days instead of denied in 6 months. Speed is meaningless if the underlying petition is not approvable. Let me address one more source of confusion that I'm seeing. People asking whether this fee increase applies retroactively to cases that are already pending. The answer is no, and it never works that way. Fee increases only apply to petitions and applications filed on or after the effective date. If you filed your case before the effective date, you paid the fee that was in effect at that time, and USCIS cannot demand additional fees just because they increased the fee schedule after you already filed. If you filed your case without premium processing and you now want to add premium processing after the case is already pending, you would pay whatever premium processing fee is in effect at the time you submit the premium processing request. But this is a separate question from fee increases applying retroactively, which they do not. Now I want to talk about the bigger picture for a moment, because while this video is focused on premium processing fees, the reality is that navigating the United States immigration system requires understanding not just individual announcements like this one, but the overall framework of how immigration law, policy, and operations function. Immigration law is created by Congress through legislation. Immigration policy is implemented by executive branch agencies including USCIS, Immigration and Customs Enforcement, Customs and Border Protection, and the State Department. Immigration regulations are published in the Code of Federal Regulations and can be changed through the federal rulemaking process. Immigration case law is developed by federal courts, including immigration courts, federal district courts, circuit courts of appeals, and the Supreme Court. When you see news about immigration changes, you need to identify which category the change falls into, because that tells you how quickly it can take effect, whether it can be challenged in court, and how permanent or temporary it might be. Fee increases like this premium processing adjustment fall into the category of administrative actions that USCIS has the authority to make under existing statutory and regulatory frameworks. USCIS does not need new legislation from Congress to adjust fees for inflation, as long as the adjustment goes through the proper rulemaking process and is justified by documented cost increases. This means that fee increases are relatively predictable and difficult to reverse once they take effect, because they're based on objective economic factors rather than political decisions. What you can do as an immigrant or as someone sponsoring an immigrant family member is plan ahead financially. Budget for regular fee increases every few years, and focus on what you can control, which is the quality and completeness of your immigration filings. Before I wrap up, I want to give you some final practical guidance that applies regardless of whether you're dealing with premium processing fees or any other aspect of the immigration system. First, always get your information from official government sources. The USCIS website, the State Department website, the Federal Register, and official policy memoranda are the only truly reliable sources for immigration information. Social media posts, WhatsApp forwards, and rumors from friends or community members may be well-intentioned, but they are often inaccurate, outdated, or based on misunderstandings. Second, if you have specific questions about how an immigration change affects your individual case, consult with a licensed immigration attorney or an accredited representative recognized by the Department of Justice. General information like what I'm providing in this video is educational and helps you understand the landscape, but it cannot replace personalized legal advice based on your specific circumstances. Third, keep copies of everything you file with USCIS, including receipts, notices, supporting documents, and correspondence. Immigration cases can take months or years, and having complete records ensures you can respond to any requests or questions that arise during processing. Let me be absolutely clear about something before we finish. The information I've provided in this video is general educational information only. It is not personal legal advice, and it should not be relied upon as a substitute for consultation with a qualified immigration attorney who can review your specific situation and provide guidance tailored to your individual case. Immigration law is complex, highly technical, and subject to frequent changes. What applies to one person's case may not apply to yours, even if the situation seems similar on the surface. Always verify information through official government sources and seek professional legal guidance before making important decisions about your immigration case. The bottom line on this USCIS premium processing fee increase is this. It's a standard inflation adjustment. It's legally required. It's modest compared to overall inflation in the economy. It affects only premium processing, not standard processing. And it does not signal any change in immigration policy, eligibility requirements, or processing priorities. If you need premium processing and your case is ready to file, budget for the new fee if you're filing after the effective date. If you don't need premium processing, or if the fee is beyond your budget, file under standard processing and plan accordingly. Do not panic, do not rush to file an unprepared case, and do not make immigration decisions based on fear or rumors. If this breakdown gave you the clarity and facts you needed, subscribe to Global Immigration Updates right now so you never miss verified immigration news analysis. Share this video with anyone in your family or community who's confused about the premium processing fee increase, because accurate information is how we fight fear and misinformation. Leave your questions or concerns in the comments, and I'll address as many as I can in future videos. Remember, immigration law doesn't change overnight, USCIS doesn't operate in secret, and when you have the facts, you have the power to make smart decisions about your immigration future. I'm Saqib, and I'll see you in the next update. Stay informed, stay calm, and stay legal.